This conversation is brought to you by philosopherstalk.com, where thinkers discuss.
Created by AITalkerapp.com. Create your own animated conversations. Link in the description.
I am Thomas Paine, author of Common Sense, The Rights of Man, and The Age of Reason. I was born in England, crossed an ocean, and became an American. I was subsequently made a citizen of France. I have therefore lived the question we are debating today from the inside, and I can report that rights do not check the paperwork of your parents before they apply to you.
I am Edmund Burke, Member of Parliament, author of Reflections on the Revolution in France, and the man who predicted with considerable accuracy what Mr. Paine's theories would produce when someone actually tried to implement them in a large country with a guillotine. I have described society as a partnership between the dead, the living, and those yet to be born, which I submit is a more sophisticated account of citizenship than anything Mr. Paine has produced, though sophistication has never been his primary objective.
The question before us is birthright citizenship, specifically whether a child born on the soil of a nation is a citizen of that nation regardless of the legal status of its parents. My position is yes, plainly and without qualification. Rights are not transmitted through bureaucratic paperwork. A child born here is here. That is sufficient.
And my position, which I will explain with the patience of a man who finds this conversation both necessary and faintly exhausting, is that citizenship is not a geographical accident. It is membership in a living community with a history, a character, and a future. A child born within the borders of a nation to parents who are not members of that nation is not, by that single fact, a member of the nation. Geography is not destiny, Mr. Paine, whatever your pamphlets may suggest.
Let us establish immediately what your position produces in practice, Mr. Burke. A child is born on American soil. That child grows up in America, attends American schools, speaks English, plays with American children, and knows no other home or country. Under your theory, that child can be declared a foreigner in the only country it has ever known. That is the concrete consequence of your organic community argument. I want the audience to understand what we are actually discussing.
And I want the audience to understand what your position produces in practice, Mr. Paine. If birth on a territory automatically and irrevocably confers citizenship regardless of any other consideration, then the nation has surrendered its right to define its own membership. It has replaced deliberate political community with a geographic lottery. Anyone who can arrange to be present within the borders at the moment of a birth has secured a permanent and irrevocable benefit for that child, regardless of any violation of law required to be present. That is also a concrete consequence, and one you prefer not to examine.
You are describing the parent's decision, not the child's. The child made no decision. The child committed no violation. You are proposing to punish a child for acts it did not commit, could not have committed, and had no capacity to prevent. Whatever remedy you wish to apply to parents who entered illegally, apply it to the parents. The child is innocent and deserves the rights of the community it was born into.
I am not proposing punishment. I am proposing that membership in a community be meaningful, which requires that it not be automatic and unconditional for everyone who happens to be physically present at a particular moment. There is a mechanism for the child you describe, naturalization. It is not a punishment to require that membership be sought and affirmed rather than simply assumed by geographical coincidence.
Naturalization for a child born here, raised here, who has never lived anywhere else. You would require a child to formally apply to become a citizen of the only country it has ever known, as though it were a late arrival seeking admission rather than a person whose entire existence has been formed within that community. That is not a remedy, Mr. Burke. That is an insult compounded by a bureaucratic process.
What you call an insult, I call an honest accounting of the relationship between an individual and a political community. The community has a right to define its own membership. That right is not cruelty. It is the foundational act by which a people constitutes itself as a political entity rather than simply a population occupying a territory. Remove that right, and you have not liberated anyone. You have dissolved the community that makes rights meaningful in the first place.
Now, Mr. Burke has been kind enough to make an argument, and I am going to do something he rarely bothers with, which is to engage it at its strongest before I explain why it fails. His position, stated charitably, is this: a nation is not a legal abstraction. It is an organic community, a living inheritance of shared culture, tradition, and history. Membership in that community is not simply a matter of geography. It is a matter of formation, of having been shaped by the community across time. Children born to parents who are not members of that community have not been formed by it in the same way, and automatically granting citizenship confuses proximity with belonging. That is his argument, and I will admit it is not without internal logic.
I am mildly astonished. You have represented my position with more accuracy than I had any right to expect. I suspect this generosity cost you something.
It cost me nothing. I have read your work thoroughly. That is precisely why I find it so unpersuasive. The flaw in your argument is your assumption about who forms the child. You assume the child is formed by the parent's community of origin, but the child you are worried about is not living in that community of origin. That child is living here, attending school here, being formed daily by exactly the organic community you claim to prize. Your own theory, applied honestly, produces birthright citizenship because the community that forms the child is the community the child was born into.
You have described one case and called it every case. The child raised entirely within the community, educated within it, shaped by it, is a genuinely different situation from a child born to parents who live in a parallel community within the nation, with a different language, different cultural allegiances, and no intention of integration. Your argument requires you to treat these as identical situations. They are not identical. Pretending otherwise is not generosity. It is imprecision dressed as principle.
Very well. I will now extend you the same courtesy you have not yet extended me, and steelman your position properly before I dismantle it. Your strongest argument, Mr. Burke, is this: birthright citizenship as an automatic and unconditional rule creates a powerful incentive for illegal entry specifically to secure that benefit for children. A policy that rewards the violation of national sovereignty with a permanent and irrevocable outcome undermines the legal structure by which a nation maintains its integrity. A nation that cannot control who becomes a member cannot be said to exercise meaningful sovereignty at all. That is your argument at its best, and I will grant that it is not nothing.
It is rather more than not nothing, Mr. Paine, but I appreciate the gesture. You have characterized it correctly, which is more than I was prepared for.
I characterized it correctly because I intend to refute it correctly. The flaw is this: you are treating the child as an instrument of the parent's strategy rather than as a human being with rights of its own. Whatever we wish to say about the parent's decision, the child did not make that decision. The child is a person. The correct response to illegal entry is to address illegal entry directly through enforcement and immigration law applied to those who actually cross the border illegally. It is not to impose statelessness on a child who committed no act and who has no other country to return to. You are reaching for the child because the child is easier to reach. That is not policy. That is expedience.
But you cannot separate the policy from its effects on behavior, Mr. Paine. If automatic citizenship is the guaranteed outcome of illegal entry followed by birth, then the policy does not merely address the child's rights. It shapes the behavior of every person considering illegal entry. You treat the incentive structure as an inconvenient detail. Legislators cannot afford that luxury. Policy produces behavior, and a policy that reliably produces a particular behavior is, in a meaningful sense, responsible for that behavior.
I notice, Mr. Burke, that we have now been talking for some time, and you have not yet addressed the 14th Amendment to the Constitution of the United States, which resolves this question explicitly. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That is not a suggestion. That is not an aspiration. It is the law of the land, enacted by the people's representatives, and it says what it says.
It says, subject to the jurisdiction thereof, which is precisely the phrase that has been contested, debated, and litigated since the moment it was written. You cite the text as though it settles the argument when the meaning of the text is the argument. I would expect a man of words to notice when a phrase requires interpretation rather than mere repetition.
The phrase subject to the jurisdiction thereof excluded diplomats and members of occupying armies, as the legislative history makes clear. It was not intended to exclude the children of immigrants. You are performing legal interpretation in the service of a conclusion you reached on other grounds and calling it textualism. I call it convenient reading.
And you are performing the same operation in reverse. You have a conclusion, which is that everyone born here belongs here, and you are finding the interpretation of the text that produces it. Neither of us is approaching this without priors, Mr. Paine. The difference is that I acknowledge mine, and you present yours as obvious.
I present mine as obvious because it is obvious. A child born here is from here. The sophistication you mistake for wisdom is frequently just reluctance to say the plain thing plainly. I wrote common sense because the argument for independence was obvious and no one was making it plainly. The argument for birthright citizenship is equally obvious and equally resistant to your ornamentation.
Obviousness is the refuge of the man who does not wish to examine what he believes, Mr. Paine. You have built a career on obvious things stated with great confidence. Some of them were correct. The ones that were correct because the traditions and institutions you were attacking had become genuinely corrupt, not because the principle of rights you invoked was sufficient on its own. Rights without institutions to sustain them are philosophy. They are not governance. They are not citizenship. They are not a nation.
And institutions without rights to justify them are tyranny. We have been having this argument for 230 years, Mr. Burke. At every turn, history has required those who share your view to retreat. Every expansion of who belongs, who votes, who is recognized as a full member of the political community has been an application of the principles I argued for and a refutation of the organic community theory you are defending. That is not a coincidence.
Every one of those expansions was achieved through deliberate political action by communities choosing to extend membership, not through the automatic operation of a geographical rule imposed regardless of community consent. You credit the principle when the credit belongs to the people who did the actual work. You have a habit of this.
I credit the people who did the work and the principle they were applying when they did it. You credit the institution and erase the argument that made the institution move. That is also a habit, Mr. Burke, and a considerably less honest one.
You are becoming agitated, Mr. Paine. I observe this because it is typically a sign that the argument is not proceeding as expected.
I am becoming direct, Mr. Burke, which you consistently misread as agitation because you have never managed direct yourself and therefore find it difficult to recognize.
Directness and bluntness are not synonyms, whatever the pamphlet tradition may suggest. One is a virtue. The other is a style adopted by those who lack the patience to be precise.
And elaborate language is not depth, whatever the parliamentary tradition may suggest. One is a virtue, the other is a style adopted by those who lack the courage to be clear.
We appear to have reached an impasse on the question of style. I suggest we note our disagreement and address it in Part 2, where I intend to be considerably less patient.
I have been less patient than you think already. Part 2 will simply make it visible.